Should we get cracking? It's 3 minutes past. Okay. Well, for those who, I think some can see us, some can't. I think everyone can see Richard. Some people are lucky enough to be able to see me, others aren't. But we've got Richard, and that's what counts. For those who have done or been to the One Chancery Lane webinars before, you'll be familiar with the layout of it all. There is a Q&A button at the bottom of your screen. So if you want to ask questions as we go through, we'll try and answer them as we go through. We've had actually quite a good number of questions already. We've tried to answer those in the PowerPoint, and we'll answer them in the presentation as we go through. We had one this morning about corporate manslaughter, which I will attempt to answer partially, but it's such an interesting question that I think we'll do a freestanding article on it actually, which will come out in the weekly roundup. So if the person who asked the question doesn't have access to the weekly roundup, our email addresses are at the end of the PowerPoint. If you drop me a line, give me your email address and I'll send you the weekly roundup and the article that answers your question more fully. But the anticipation is that we will try and answer your questions as we go through. The last webinar that we did that I did with Dom Smith worked, that was a couple of weeks ago. That worked really well because people were asking questions throughout as we went through. I was answering them while Dom was talking. We would plan to do that again, but Richard and I are going to spread the load a bit more evenly today. So Richard's going to talk first, and then I'm going to talk a little bit about litigation once he's given us his views on how the travel industry is responding to the COVID-19 crisis and how he sees it responding in the short to medium term. Then I'm going to talk a bit about litigation. So while he's talking, if you ask questions as regards what he's saying, and I'll answer them, while I'm talking, he'll answer the questions that you've got for me. At the end, there'll be an opportunity for both of us to answer questions. If you have any questions about anything we've said, if you've got any questions about the travel industry generally. So that's how we would plan it going. We're due to speak for about 45 minutes. I would have thought half an hour to 45 minutes, depending on how many questions you ask, how interested you are in drilling down into the detail of it. So that's the plan for today. With that, I think I'll hand over to Richard, but it really works if you participate and ask questions that you have. Don't be shy about asking questions. There's no such thing as a stupid question, only a stupid answer, as we will see when Richard begins to answer your questions. So let's get cracking on Richard's part, which is a more general part about the industry and how he sees it going.
Good morning, everybody. So I'm going to be doing the first sort of say 6 slides or so, and then as Sarah said, I'll hand back to her. I'm the sort of warm-up event, and Sarah is very much the main event. So I'm going to apologise at the outset for being perhaps a bit flat. It's because it's quite difficult to brim with enthusiasm and energy when I'm essentially speaking at my laptop in an empty room, and I can't see anyone else's face apart from Sarah's, who is just glaring at me with some disdain. But I should say it's no more unnerving than the trial that I did last week over Microsoft Teams, so with video, when midway through the opening remarks, so some interaction between the barristers and the judge, my witness WhatsApped me just to let me know which celebrity he thinks I look like, which he seemed to think would be helpful for my submissions. And before anyone asks, I know some of the people who are in attendance who will say this so I don't preempt them, it wasn't Phil Mitchell, and neither was it Britney Spears in 2007 when she shaved her head. Sorry?
Who was it?
I'm not saying. It was quite good. It was pretty good. 10 points to Gryffindor for whoever can guess it. No, I was pretty pleased with it. It kind of G'd me up. It wasn't Mark Zuckerberg, because I've heard that one in the past as well. A Moroccan passport control officer once, when looking at my passport photo, said, "Oh, Mark Zuckerberg," which was good. So slide number 2, the beginning, standstill and stoppage, some alliteration and some nice harsh syllables there. So we've got the body of the text there in the white writing, some reference to the FCO's advice, essentially not to travel. and then the WTT giving some quite dire forecasts. Now, I don't wish to bombard you all with overly bleak data, but the industry really, I think it'd be fair to say, is on its knees. It's not dead, it's not absolutely, on the ground, but it's certainly down. Now, to my mind as well, probably the best, because there are a number of different ways you can look at the industry, but I think probably and in the time that we have, the best barometer for the health of the industry, certainly in terms of consumer appetite for international travel, the best barometer is the airline industry, which has taken an absolute pasting. Now, I read a very good article this morning published by Stewart's, who are a law firm specialising in this area. That was on the future of aviation claims. I can recommend that. But generally speaking, the industry as a whole, global air traffic is down by well over a half. As of 2 weeks ago, there were 17,000 passenger jets grounded. Flybe has gone into administration. As we all know, very sadly, a number of the other airlines, both domestic and foreign, have experienced enormous job losses. So BA, for example, has lost, I think it's about 12,000 members of staff, which is about a quarter of its workforce. Virgin have lost high numbers. Ryanair have lost high numbers. Across the pond, Boeing is in real difficulty, bearing in mind also that this is off the back, for Boeing, it's off the back of their 737 problems as well. So they're in quite dire straits. This is the kind of high-tech, sophisticated research that I do. And I'm also such a nerd that I rip out from newspapers articles that are relevant for work. And I did this actually in advance of even knowing that I was doing this talk, which I think probably reflects on the fact that I need to get a life. But so the title of this article is Issue of the Week, and it's in the City section of this periodical. And the title is just Aviation Meltdown, which I think probably reflects on where we are. But also in terms, as well as the airlines, this is what's most interesting and also worrying. Is it's not just the airlines as you'd probably expect. It's also their suppliers. So Rolls-Royce having problems, General Electric notably, and also from a domestic point of view, Airbus, which has its factory in the north of Wales, is fighting for survival. It's not just suppliers; it's also, probably most worryingly, even airports. So, I've read about Gatwick. There being doubts about the long-term viability of Gatwick, which is bizarre because one tends to think of airports as being these sort of behemoth, too big to fail institutions that just will exist. And it's funny to think that things are so bad that even the airports are in difficulty. So if we move then onto the next slide, which has some more lovely alliteration. It's entitled Short-Term Solutions. So really we've looked at the problem, the state of affairs. Now we're looking at the EU's immediate arsenal of reactions just in regards to liquidity, really. So the EU has mercifully, and I think probably wisely, relaxed rules on state aid. And we've seen a couple of notable examples of that, principally in Germany. So, for example, the German government reached an agreement with TUI, and this was a while ago now, so sort of towards the start of lockdown. But they reached an agreement for a 1.8 billion euro bailout to be provided by the state-owned development bank KfW, which is quite interesting method of doing that. Similarly, in terms of airlines, most recently, I think it was a couple of days ago, Lufthansa have reached a 9 billion euro bailout agreement with the German government. So, I mean, just the sums involved there, particularly from a country as ordinarily tight with its purse strings as Germany. It's quite concerning news. There are, however, some naysayers, as one would imagine, probably most vocally Ryanair, with his characteristic empathy and good grace, the chief exec of Ryanair, Michael O'Leary, who's never one to be far from the headlines, he has compared these airlines receiving aid packages, he's compared them to crack cocaine junkies, which I think is kind. Similarly, Big Donald, the Donald in America, in his characteristic warm embrace of internationalism, he has expressed an unwillingness to assist any cruise operators not registered in America. So there are some naysayers and protectionists who are, saying that in the case of Ryanair, saying their competitors should be helped. As well as the immediate, if we move on then to the next slide, it should be, yeah, there we go. Again, more alliteration, isn't this wonderful? It's entitled Cartography and Creativity. Now, so really we've looked at the problem, the state of affairs. We've looked at what the EU has done for the immediate short-term liquidity problem. And then really what this slide is about is the more short to medium term practical approach the EU has taken with trying to get tourism going again. Now, the main thing to look at there is the joint European roadmap, which is produced by the European Commission. Really, it's just, it's a guidance and recommendation document which lists a number of practical things that member states should be doing when tourism and cross-state movement get going again. And it goes all the way from the level of airports right down to restaurants. So it's quite a comprehensive document. It includes things like, for example, staying in the car if you want a short ferry route, which makes sense. And also separating different passenger flows at transport hubs. I'm a bit cynical about that because I'm not sure, given the numbers of passengers at airports, for example, how you logistically could possibly keep all of those different queues separate from one another. I query whether, so this guidance is non-binding from the EU, but I wonder, more just thinking aloud than anything else, I wonder whether non-compliance with it, for example, by an airline, whether that could form the basis of a Montreal claim. It's an interesting question. Maybe one that Sarah will come on to. I actually genuinely don't know if she will, so maybe she will. If we move on to the next slide, entitled Roadmap and Reality, again, alliteration, brilliant. There are three things described there: air bridges, travel bubbles, and epidemiologically equivalent countries. So what we can take, at least at first blush, is that there will be a barrage of confusing new terms. An air bridge, it's essentially, I don't really understand what the air and the bridge part of it has to do with anything, but it's a bilateral agreement between two countries, essentially not to impose quarantine measures on citizens that from your country that are returning back from holiday from the other country. Good examples of this, good mooted examples have been between the UK and France, most recently between the UK and Portugal. I think that was yesterday evening's news. A travel bubble, on the other hand, I can't figure out what's different between a travel bubble and an air bridge. It's a similarly ludicrous name. I suppose it could extend simply by nature, the physical nature of a bubble. It might extend to a region as opposed to simply sort of bilateral corridor. But a good example of this would be the agreement that's being considered between the New Zealand and Australia. Moving on, epidemiologically equivalent countries. So this is the idea that there could be measures in place, some agreements reached at a certain point between countries which are presenting clinically as such in similar ways in terms of the number of infections, the R number. Cynically, I imagine any such agreements would be quite politically charged because, as we're seeing at the moment in terms of the international communications, there's certainly a lot of realpolitik at play. If we move on to the next slide. Oh my goodness, there's more alliteration, countries and contrasts. So we've looked now at the problem itself and the state of affairs. We've looked at the EU's immediate approach towards liquidity. We've looked at the EU's approach towards the short to medium term, how to get tourism going again. Now we're going down one step further and looking at the different approaches the different countries have taken, often quite divergent. So we see there's reference to the Turkish trial, hygiene certificates. Now, hygiene certificates are a kind of internal domestic audit for businesses and hotels, so businesses like hotels and airlines and things like that, to be able to demonstrate their hygiene. For those of you who do travel claims involving foreign hotel suppliers, I imagine it will be something like those the internal audits you see the hotels producing, where the hotel itself says that it's doing a good job, which is pretty much meaningless. It's about as much use as a sort of cardboard cricket bat. Moving on, Dutch doubts limiting tourism. So the Dutch, probably reflective of the fact that they're a very wealthy country and they can afford to take this stance. They have expressed, principally the mayor of Amsterdam has expressed great caution about readmitting tourists. Bookings, have been as low as, as 90% down from normal. There's reference there to the Spanish stall. No tourism until Christmas, or will that be July? So Spain has been quite confusing about its communications of when and if it will let tourists back in. There was talk of it being Christmas, then there was talk of it being July, then there was some talk of it being for everyone except British people. And then I think they've realised that they desperately need the money, so they've opened it up seemingly to everybody. I think that they could reflect, to a degree, that the confusion could reflect the political fragmentation in Spain as a country, and the difficulty that the powers that be must have had in trying to reach a mutually agreeable position for the wildly different stakeholders in Spain. And moving on, Italian inflation, raising prices. So this is referring to the speculation that Italian tourism businesses will be forced, or will just choose to dramatically increase prices to cover their recent losses. Now, I'm not convinced that will actually happen. I think this is more just fear-mongering, because to my mind, tourism businesses will generally charge as much as they can get away with. So if it is the case that tourists will pay these greatly higher sums, I see no reason why that wouldn't have already been the case pre-corona. Maybe I'll be proven wrong. Moving on, the Greek gradual reopening. So the Greeks have mooted this idea of a health passport, which is, it's essentially a glorified doctor's note saying that the traveller in question is fit to travel. It's quite bizarre. Much like the Turkish hygiene certificate, I think it's probably a bit gimmicky, but it's a way of just trying to make tourists feel a bit more comfortable about travelling there. Again, we see reference to the Baltic bubble. This is just another of those confusing bubble agreements between a number of Baltic states, and the UK October bank holiday. So that's the idea that there'll be another bank holiday in the UK in October. Obviously, for a self-employed barrister, a bank holiday means almost nothing, but I have heard they're quite fun things, much like evenings and weekends. The big news, I can see Sarah smiling knowingly. The big news as of last night was that the Cypriot government have said that they will meet the costs of travellers who go to Cyprus and contract COVID, subject to a couple of things like repatriation flights, but generally speaking, they'll cover everything, which I think just reflects how desperate a lot of these countries are, which typically experience high numbers of tourists and who are economically quite dependent on tourism, how desperate they are to get it going again. So, for example, Turkey is a country that it depends on tourism for about $35 billion worth of its economy. It's obviously, now that the immediate panic and scare of Corona has worn off somewhat, they're now realising that they desperately need tourists. So moving on, yet again, I'm doing time, I've dragged on a little bit, I apologise. This is just sensational alliteration. Quixotic quarantine. Who knew there would be something that would alliterate with quarantine? I take all of the credit, obviously. So it explains this slide that, as you all will have heard, the UK has proposed a 14-day quarantine for British tourists, and this is after the 8th of June. So, for example, you know, British tourist on the 9th of June goes abroad on holiday, comes back. That tourist would have to spend 14 days in self-isolation, aka quarantine. I believe a question was asked in advance of this webinar as to whether that will apply to short breaks. The answer is yes, it will. It will not, however, apply to travellers arriving via Dublin, for reasons explained in the slide. Now, I understand that some travel operators are considering selling foreign holidays that go elsewhere, albeit return via Dublin, to get around this quarantine measure, which strikes me as being rather clever, if not ever so slightly cunning. But so that will be an interesting development. As it says there as well, this quixotic quarantine will not apply to future air bridges or bubbles or whatever they are. Now, so your warm-up is done. I now pass you over to the main event. Thank you very much.
Thank you, Richard. Yeah, we've had lots and lots of questions about refunds. And those people who are lucky enough to get the weekly roundup by One Chancery Lane will know that this is something that's been exercising us for the last couple of months. It's been a really big issue, and I think it's caused a lot of damage to the industry because a lot of people's holidays have obviously been cancelled this year and they were entitled to refunds. So they were entitled to refunds from their airlines in relation to the flights under the denied boarding regulations, Regulation 8, but they weren't entitled to compensation under those regulations. They were entitled to refunds if they had a package holiday under the package travel regulations under Article 13 of either of either the first package travel regulations or the updated ones of 2018. To holidays booked after the 1st of July 2018. So there is no doubt that if a consumer's holiday is cancelled, they are entitled to a refund either from the airline or, if it's a package, from either the airline or the tour operator. That hasn't happened. And it hasn't happened for quite understandable reasons, because both the airlines and the tour operators are inundated with requests for refunds. And just processing them is a really difficult process. Under the package travel regulations, you're entitled to a refund within 14 days. I mean, that's just not, it's just not possible. The European Commission quite early on issued guidance that consumers ought to think about taking vouchers instead of refunds. And the reason for that, of course, is that if all holidaymakers take refunds on all their holidays, and if tour operators and airlines are not booking alternative holidays, which is what's been happening, they actually go into deficit. So airlines and tour operators are getting no income, but they're having to pay out on refunds. And so the Commission tried to ease that situation by recommending that consumers should be prepared to take vouchers. One of the questions we had before the webinar rather pithily just went refund or voucher. Consumers have almost with one voice gone refund. And the reason for that, I think, is that as matters now stand, if you are offered a voucher by an airline or a tour operator, there is no guarantee, no clear guarantee, that if that airline or tour operator goes under, that voucher is going to be worth anything, because there's been some doubt as to whether or not the ATOL scheme protects them. And the government did suggest putting in place a scheme to underwrite those vouchers. There is no such scheme in place. That's something that was suggested about a month and a half ago. Nothing has happened. There is a suggestion that the Council of Europe has a majority of member states who want to derogate from the directive. Some countries have been unilaterally derogating. So in Italy, the airline or tour operator has a choice as to whether to give you a refund or a voucher. It seems to me that that does not comply with the directive, and as such, the Italian government is probably vulnerable to a Frankovich-style challenge to that, in that that is not lawful under their treaty obligations to Europe. It's a mess. It's a mess. So at the moment, we're seeing lots of claims being made for vouchers or for refunds, and they're A, not being processed, and B, the industry just does not have the liquidity to satisfy all of those claims. But as a matter of law, those refunds are payable. And I think that is an area where we are going to see litigation inevitably. In relation to refunds, there is other recourse in relation to consumer rights. They can either make a Section 75 claim under the Consumer Credit Act, under which you have a like claim against your creditor if you booked on a credit card. Doesn't work for debit cards, but if you booked on a credit card, you have a like claim as against the credit provider as you would have done against either the airline or the tour operator. So there is a Section 75 claim available, and it seems to me that that's pretty copper-bottomed, because there is definitely a legal right to refunds as against the tour operator or airline, and therefore there should definitely be a claim available as against the creditor. A lot of people book their holidays on debit cards rather than credit cards. For those people, there is the additional option of chargeback, which is where you ask your debit or credit card provider to give you a chargeback, i.e. they repay you the sum that you paid on their card, and they then go after the supplier. So then NatWest or whoever it might be then makes a claim against the tour operator or airline. That is not enshrined in statute, and so it is not a strict legal right. However, it is a chargeback, is within most terms and conditions for most banks, and therefore, if they reject your claim for a chargeback, there is an argument that says that that's not reasonable and that they're not complying with the terms and conditions of their contract with you. So again, some litigation I think to be had about that, about whether or not you can enforce your rights under chargeback or not. Certainly the banks at the moment saying that you can't, but a lot of consumer groups saying actually that's not right, because if it's within, it's one of the inducements that induces you to enter into a contract with your bank, and therefore it ought to be enforceable. In relation to refunds also, we're seeing claims being made on travel insurance, a lot of those being batted back by insurers because they say that they are really a safety net, as it were, so that you're only entitled to make a claim on your travel insurance if you have already claimed against the airline or tour operator, and if that hasn't worked. That I think is a strict matter of law is probably not right, and therefore I think there is a freestanding claim which runs alongside and parallel to the claims against tour operators and airlines, and the chargeback claim and the credit supplier claim. There is, in addition, if you have travel insurance, a claim against your travel insurer as well. They would then have a right to recoup their losses, obviously against the tour operator or airline. Business insurance, seeing a lot of difficulties with that, and insurers counterclaiming as well. So looking at business interruption insurance, for example, a lot of insurers not paying out on that. Certainly our own insurance, One Chancery Lane, refusing to pay out on business interruption insurers, although what could be more interrupted than Richard sitting in his sitting room and me sitting outside Temple Church giving webinars, rather than going to court. But a lot of business interruption insurers not responding because they say it's not covered. And as you'll know, of course, there is a case going on with the FCA at the moment where they're calling for consumers and insurers to make representations to them about the legality of that, and there's going to be a test case about that, about whether or not business interruption insurance responds in these circumstances, which is going to be a pretty big claim, I would have thought, or pretty big case, I would have thought. And some insurers making counterclaims against businesses for failing to provide what they ought to have provided. So, for example, business interruption insurers, people making a claim against them, and then their counterclaim against their insured for not providing, for example, the weddings or other events that they said they would provide. How attractive that is a counterclaim, I'm not, I wouldn't presume to say. In relation to claims then, other than refunds, what are we going to see? We were asked before the webinar the question whether or not COVID-19 is going to be the new gastric illness. I don't think so. I think there are some real difficulties with COVID-19 claims as opposed to the gastric claims. You'll recall, of course, in Wood and Toohey that the Court of Appeal said that there's a sort of quasi-strict liability with gastric claims. So where a foreign hotelier provides all the food that a holidaymaker eats for a 14-day period, and they get ill on day 7 with, let's say, salmonella, the incubation period for which is a few days, then A, it's pretty obvious where they got that salmonella from, and B, you don't need to prove the hotel was at fault and the fault led to the food poisoning because of the Sale of Goods Act, which says that when you provide food to someone, it has to be of satisfactory quality. If it makes you ill, it's not satisfactory. COVID-19 is slightly different because it's an airborne virus. So the Sale of Goods Act isn't going to come into play in relation to that. So it's not going to be strict liability in the same way that gastric illness is. Secondly, there's an issue of causation. Where did you get it from? It's really, really contagious. Can you say that you got it from something said or done in the hotel? Can you say you got it from a member of hotel staff as opposed to another guest? If you got it from another guest, how could the hotel have stopped that situation arising by taking reasonable measures? So that's why I think COVID-19 is the new norovirus, where you can bring claims for norovirus, but only where you can show that the supplier ought to have done something that would have prevented you from getting norovirus. So where, for example, there's a really big outbreak, and you'll remember that case, the hotel in Lanzarote, I think the H10 case, hotel in Lanzarote, where an Italian doctor goes to this hotel, unbeknown to him, he's got COVID-19, he gives it to a whole load of people at the hotel. If a tour operator, knowing that, then sent more guests to that hotel, knowing there was an outbreak there and that they were about to be quarantined by the authorities, I could see, yes, a claim could be made that they should not have sent guests there at all. But those are really particular circumstances. It seems to me that the guests that were already there couldn't bring a claim because they couldn't show the tour operator knew or ought to have known that they would suffer some injury as a result of being sent to that hotel. So I may be completely wrong about this, but I actually don't think we're going to see a lot of claims arising out of COVID-19 outbreaks because the outbreak was so quick and it's so new. We may over the coming years see them in the way that we see the occasional norovirus case, but I don't think it's going to be like gastric illness. The only exception to that being the cruise operators, because we do have some allegations being made and indeed litigation being initiated in America and Australia about cruise operators and ought they to have allowed people to take cruises because some of the cruises began after the outbreak began. Ought they have allowed people to go onto the cruise ships where they already had COVID-19 on them? That is going to be, I think, a big area of litigation that we're going to see in the way that we used to see lots of norovirus claims arising out of cruises. We were asked this morning about corporate manslaughter. Could cruise operators be exposed to charges of corporate manslaughter arising out of deaths on cruise ships? I think this falls into two categories. First, passengers, secondly, crew members. So the duties that are owed are different in relation to those two categories of person on board ship. We have done some articles about crew members and to do with liability and employer's liability, so I don't propose to deal with that here. In relation to passengers, the answer to that, I think, is maybe, rather unhelpfully, but it depends on where the cruise ship is. So, for example, in the UK, our corporate manslaughter law only relates to harm arising where the ship is registered in the UK or where it's in UK waters. And most of the vessels that we're talking about that are affected by COVID-19 are neither registered in the UK nor are they in UK waters. So I think that's the short answer is, as regards UK law, probably not. And the other thing that I think in relation to that is that it would be very difficult for the DPP, who has to give permission for corporate manslaughter charges to be brought, to give permission for such a charge to be brought in circumstances in which we haven't done a lot to help those cruise ships. So we did an article, I think it was you and me, Richard, did an article a couple of weeks ago in which we looked at what is happening on the cruise ships. And effectively, at that time, there were 100,000 crew members floating around on about 100 cruise ships. And they weren't being allowed into port anywhere because all the port authorities were afraid they might have COVID-19. If you can't get people off the ship, it's very difficult to see how you can be charged with corporate manslaughter arising out of any deaths that might then arise. A lot of these ships are off the coast of America. Now, not only will the Americans not allow them off the ship, they're also refusing to provide them with medical treatment if they require it as a result of COVID-19. Now, it does seem to me that the Americans would then find it very difficult to bring any charges of corporate manslaughter in relation to a situation which their own policies have given rise to. So I think the answer to your question is probably no, as much as anything for public policy reasons. But we will do an article on that, and I will send it to you in the weekly roundup because it's an interesting question, not one that had occurred to me. So thank you for that question, the person who raised it. So just very briefly on foreign resorts and hotels, we were asked if a foreign hotel remains open but the holidaymaker can't get to it due to lack of flights, can the holidaymaker get a refund? The answer to that is it depends, again. If you've got a package, yes, you can get a refund because you can't actually perform your side of the contract. You can't get to the hotel, so it's of no use to you. In relation to freestanding contracts with the accommodation provider, so where you've booked your flights and accommodation separately and you've done it yourself, it depends what law applies. If English law applies, the contract has been frustrated or it's been subject to force majeure, and that means that you can get a refund. If foreign law applies, you would have to look at that foreign law. But in most European destinations, you would be able to get a refund, but it depends on what their particular civil code has to say about that. But certainly in English law, the answer to that is yes, you can get a refund. Will consumers be able to bring claims against foreign suppliers? Would the English courts have jurisdiction over any such claims? That is a whole different can of worms, I'm afraid. We will have to do another webinar about jurisdiction enforceability post-Brexit because, partly because nobody knows the answer to it at the moment. Secondly, because it would take me an hour to even explain the question, let alone start to explain the answer. The answer at the moment is the English courts would have jurisdiction over claims arising out of consumer contracts as between a consumer and an accommodation supplier. They would also have jurisdiction over any claim made against the supplier's insurer directly, subject to any territorial restrictions there may be on that contract for insurance. After Brexit, at the moment, we are staring down the barrel of no jurisdiction, no enforceability. So as matters now stand, the English courts would be looking at questions of what is the most appropriate forum for any such claim to be brought. It's going to be a lot more difficult after Brexit unless we manage to get ourselves signed up to the Lugano Convention. But as I say, that's an entirely new subject and one that we probably ought to deal with once the Brexit negotiations reach a further stage in the negotiations. So I can't really answer that question at the moment. At the moment, yes, we do have jurisdiction. Whether that's going to translate after Brexit ends is difficult to say. So there's been a lot of doom and despondency, particularly from Richard. It is true to say that consumer confidence in the industry has been all but destroyed and the refund disaster is ongoing. They've all suffered. Industry insurers and brokers have also been the subject of criticism because it's being said that brokers ought to have ensured that insurance covered these situations. There is some reason for doom and gloom. However, we at One Chancery Lane believe in redemption and resumption and indeed optimism. There is a pent-up demand for holidays. The number of people Googling to look at holidays has skyrocketed lately. And they're looking for September, October this time, and they're looking for this time next year as well. So April and May are expected to be pretty boom months for the industry if they can weather this storm. And people are prepared to accept quarantine as the price of a holiday abroad. So there is a feeling that people do still want to go on holiday, even if they're grumpy about the refund situation at the moment. So there is optimism, there is grounds for optimism, and there is an opportunity here to get consumers looking at destinations they might not have looked at had this crisis not occurred. So things like the health and hygiene certificates that Richard's rather cynical about, those things might convince consumers to have more confidence in suppliers. And it's right to say also that the European Commission is looking at and doing a lot of work on this, and so is the UN World Tourism Organization. And they're all trying to find a way of getting people more confident in the industry. And they've realised that actually we need the industry because people do want to go on holiday. And not only that, but it does employ a huge number of people. And some of the countries in Europe is really, really fundamental to underpinning their economy. So I think we are going to see more help from nation states. We are going to see more assistance given to the industry because the Commission seemed to be quite laissez-faire about it at the beginning. I think they've now taken on board that this is a real worry, which perhaps they ought to have realised before now, but that's not a matter. So I think there is room for optimism, but there's going to be a lot of restructuring, and we're seeing that happening already. And there are going to be casualties, but some of those casualties are going to be those businesses that were not very well structured in the first place. And so for the ones who come out the other side of this, for them, there's going to be a very big pool of people all wanting to go on holiday. So I think there is grounds for optimism, both for the industry and of course for our profession, which depends upon it. Now, where are we? Yeah, 45 minutes, absolutely perfect. Any questions? Let's have a look. Richard, have you revealed your great reveal as to who it was? Unmute and tell us all. My money's on Judge Rinder. I think it was an active yes.
There have been a mixture of very complimentary and then very savage suggestions. I can't think. Greg Rutherford, Jason Statham, Ross Kemp, Matt Lucas, that was just mean. Judge Rinder, Peyton Manning, quite an obscure reference. Joseph Gordon-Levitt, pretty complimentary. Lance Armstrong. It was actually, drum roll, Heath Ledger.
Heath Ledger.
I know. I was really pleased. I was absolutely delighted.
I bet you were.
I could barely concentrate on the trial. I was so pleased.
Now, are there any questions we need to answer other than questions relating to your appearance?
There is one question, Sarah, from Rosalind Young. It was more to do with your content, so I've left it for you. But it's, what is the current position regarding curtailment of a holiday as opposed to a cancellation where it may not be covered by the travel insurer?
Yeah, that's an interesting question.
Thanks, Michael. Agreement.
The answer to that is again going to be it depends, because it depends on the terms of the travel insurance policy. If curtailment's not covered, it's not covered. But most of them do actually cover it. But don't forget, if it's a package, under Regulation 15, you owe a duty to provide assistance in resort. So even where something's gone wrong that isn't the fault of the retailer, they still owe a duty to provide assistance to their holidaymaker when they need it, if they get into difficulties when they're in resort. So I think that's covered by that. You may not owe a duty to repatriate them or to bear the cost of repatriating them, but you do owe a duty to give them assistance. So yeah, I think there is curtailment. If it's not covered by travel insurance, which it mostly is, then it's going to be covered by Regulation 15.
Sarah, we have another question from Thomas Yarrow, who I should say is our latest tenant in Chambers. He has asked if the claimant has booked a package to Spain in July, which is not cancelled, and the tour operator wants to push for it not to get, and the tour operator wants to push for it to go ahead because Spain is open, but the claimant doesn't want to go, can the claimant terminate the contract and get a refund on the basis that there's been a material change to the agreed terms of contract?
It depends what the, and you trespass on personal grief here, because I've actually got a holiday booked in Naples in July. And the answer to that is, at the moment, I'm not attempting to cancel it, because at the moment we don't know whether or not it can go ahead. I think it depends what the FCO guidance is by then. If the guidance is still, we advise against all but essential travel indefinitely, by the time you get to a couple of weeks before the holiday, I think you're entitled to cancel it and you're entitled to a refund, because at that point, the holiday clearly can't go ahead. If the guidance is, yeah, you knock yourself out, go abroad if you like, but when you come back, you've got to quarantine for 14 days, which appears to be likely to be where we're going to be at that point, it becomes a question of fact as to whether or not that changes things to such an extent that you're entitled to a refund. And personally, I think it probably does. Although actually, as you rightly say, for barristers, if we quarantine for 14 days, I mean, what difference is it? You know, we're still sitting on our sofas for 14 days. But for normal people with actual normal lives and jobs and stuff, yeah, I think it is. I think that does change things, the fact that you've got to quarantine when you come back. So I suspect the answer to that is wait and see. Wait until it's clearer, because if you cancel your holiday as a consumer and there's still a flicker of hope that it could go ahead, which is the legal term, if there's still a flicker of hope that it could go ahead, then you're not going to get your refunds. So you have to wait till the last minute and then cancel, or wait for the tour operator to cancel. Now, I'm very conscious that we're going over our 45-minute allocated slot. So please don't feel that you have to stay just to support Richard in his "Who Does Richard Look Like" poll.
That's unfair.
We'll stay and take any questions and answer any questions you may have.
I was about to say something we need to raise, which is that next week, before anyone does leave, just next week there's going to be another webinar. I believe it's Dom Smith and also Sarah. Is it you again?
No, it's Francesca.
It's Dom and Francesca. Yeah, are doing. I think it's a clinical negligence webinar. So that will be an inquest related, I believe.
Inquests.
Inquest.
I was looking at questions and not listening to you, Richard, so I allowed you to go off on a frolic on your own, which is always a mistake. Jessica and Dom speaking on inquests, COVID-19, and Article 2, I believe somebody said, which will mean something to people unlike me who know what Article 2 is. So that's 11 o'clock next Thursday, Francesca and Dom giving a webinar about inquests. We're having lots of discussion about air travel. Hi, Fad. Yeah, there is still some air travel taking place. Stan, oh, hi, Stan. There is still some air travel taking place, but lots less than there was previously. And to the extent, as Richard said, that Gatwick's looking a bit unstable. Looking to fly, but some destinations are still closed. That's right. Does FCO advice against travel automatically mean the holiday is cancelled? It doesn't automatically mean the holiday is cancelled, but it does justify cancellation. So if the FCO is advising against travel, it means you can travel if you want. So both the tour operator or airline and the consumer can choose to continue with the holiday. But if you do, you will invalidate your travel insurance, because travel insurance, generally speaking, doesn't apply where you've chosen to travel against FCO advice. Secondly, it will justify either the consumer or the tour operator in cancelling the holiday. So it doesn't automatically cancel it, but it does give each of the parties to the holiday contract the right to cancel it if they want to. And particularly at the moment, it would be quite a brave consumer who went abroad in the face of FCO advice, because they wouldn't be covered by their travel insurance. So they wouldn't be covered for example, repatriation, if suddenly the borders looked as if they were going to get closed, or there was a second spike, or airlines were grounded. And they wouldn't be covered if, for example, either our borders closed or the country they went to's borders closed, which might mean that they were stranded somewhere. And, you know, for example, needing hotel accommodation for another 3 weeks or a month, or depending on how long the second spike went on for. So I think it'd be pretty brave to travel in the face of FCO advice. I think it's always pretty brave, but particularly at the moment where pretty much every country in Europe is experimenting with the second spike, because we could quite easily see, let's say you went to Spain for 2 weeks, you could quite easily see on the second day of your holiday a second spike in either England or Spain, which would give rise to borders closing. So if you go abroad now and you don't have travel insurance, you're pretty brave. Let's see, what other questions have we got, Richard?
There was one asked by Graham Lynch on the chat little box saying, do the panelists have experience of airline refund claims in Australia and or whether they have an equivalent to the EC 261?
No, I think I'm not qualified in Australian law, so I can't answer that with any degree of confidence at all, but that's not going to stop me from attempting to. I think the answer is the Australians don't have an equivalent to ours, but they do have their common law. And under their common law, they've got the same rules about frustration and force majeure. So they've got a similar setup in relation to refunds, but not compensation. But compensation doesn't come into play for us anyway. So I think it's similar is the answer to that, but not the same. And the same in America as well. And in Canada, they are bringing litigation against 4 Canadian airlines. And it seems to be, although they don't have the same rules on the same, obviously, EC regulations as we've got that apply, they do have rules about frustration and force majeure. So it's just, you go back to basics with contractual claims for the Commonwealth countries.
So we then have a question from Sandeep asking, what can tour operators do going forward to ensure they can secure a recovery from their supplier in events such as this, particularly once the transition/implementation period has ended? That question is just honest.
Yeah, I mean, the answer to that is quite a lot. Certainly some years ago when I used to advise tour operators about their standard terms and conditions for their supply contracts, quite a surprising number of them didn't have written contracts with their suppliers. So for one reason or another, either it had always been done that way or it was done by the reps in resort, or they'd never had it. They just didn't have anything that said anything about this situation or any other situation in writing. Some of them had written agreements that were pretty poor, some of them had quite good ones. I don't know to what extent that's been standardised better. Certainly for tour operators that I advised, it ought to have been standardised better. I think the answer to it is there ought to be supply contracts which provide that in the event of frustration of the holiday contract, the supply contract comes to an end and there is an indemnification and the funds come back. I take the point that quite often you have that with suppliers, but the funds don't in fact come back. The answer to that is, well, you're going to have to sue them. And you're going to have to sue them either in the courts of their domicile or you sue them in the courts of your domicile, assuming that you have an English jurisdiction clause in your supply contract, which a surprising number of tour operators do not have. So you just sue them in the usual way. Going forward, there is discussion at UN and EC level in relation to where the risk should fall of this happening again or a second spike. And that's something, I'm giving a webinar next week to the UN WTO, and in the weekly roundup next week we'll be asking for your thoughts about that to do with where the risk should lie. Because at the moment, the risk of something like this happening again lies completely on tour operators and as a safety net on the insurers. But the insurers are very much saying it's your risk, you know, because of the EC regs, they put the risk onto the tour operators and that is where everyone intended it should lie. The problem with that is that it is going to cause a real problem for the industry. And if the industry collapses, it's not in the best interest of consumers or insurers or anyone else or tourist destinations. And so they're in the UN WTO convention, which they nearly signed off but didn't quite get over the line. They suggested that some of the risk should be borne by the member states, by the actual individual tourist destinations. So that if something like this happened again, a nation like Spain or Greece would pick up part of the tab for this. I find that difficult to conceptualize because it means that money flows from the tourist destinations to the member states which send more tourists. And that would mean you'd get money flowing from Spain and Greece and Portugal to England and Germany. which is kind of counterintuitive compared with what we've seen in recent times in relation to Europe. But at the moment, the idea they're working on is that the actual tourist destination will bear some of the risk. So it may be that going forward, if that can be put in place, and the industry should be lobbying for that, I think, if that can be put in place, it may be that you'll find you don't need to sue the supplier because you can just ask the Spanish government or whoever it may be for compensation, and then they get the compensation back from the hotelier or whatever it may be. So there is discussion around that, but we don't know is the answer. We don't know yet how that will work out. So what have we got? Oh, one from your friend Mike. What if you can go, but the holiday is going to be less enjoyable because of restrictions? Yeah, absolutely. The answer to that is it's a matter of degree. So you'll remember in the package travel regulations that if you can't provide a significant proportion of the services under the contract, then you can treat it as being cancelled. So if, for example, you've got a holiday to Disney World, that's a 2-week holiday to Disney World, and it includes all the entry to the parks and so on and so forth, and the parks aren't actually open, or there's such a degree of social distancing in the parks that it's even more of a nightmare than it would otherwise be, then you will have a right to cancel the holiday. So the answer to that is it depends on whether it's a significant proportion or not.
Sarah, we had a question on the chat box as well. It's Emma Williams, who's our marketing director, forwarded a question from, that was emailed by Michael William. Refunds, can a tour operator agree to give a refund and pay back the cost of most elements to the consumer, but defer payment of the rest until they get the cash back from an airline?
No.
And Michael's given his own postscript, which is that they cannot.
No, no. As always, I agree with Michael. One of the most reasonable solicitors in the entire area. No, they can't. I mean, there's nothing in the package travel regulations that says you can do that. So you can't. It might be justifiable. And actually, it's happening quite a lot because they're saying, well, I'll refund you the accommodation and I'll refund you the airline fare when I get it back from Ryanair, whoever it is. But there's nothing in the regulations that say that that's permissible. So legally, you can't.
Christy,
consumers are a bit more understanding about that.
Christy can make a similar point about the tour operator recovering from their supplier because the dispute he's having with Trailfinders involved them saying to him that they don't have the resources to go after their supplier. So it seems to be that notwithstanding clear legal obligations, tour operators may be trying to take these angles just to limit as much as possible what they have to pay.
Yeah, I think it's to do with deferring it because it's all happening at once at the moment. So once they get some more cash flow, so they either get liquidity injected in the way that the German government injected liquidity into TUI. If our government were to do that for our tour operators, then I imagine that refunds would start moving again. Either that happens or they start taking more bookings for next year as people get more confidence, and that means they've got the cash flow that enables them to process refunds. But at the moment, it's quite difficult for them to process refunds in circumstances in which they're not getting them back themselves from the airlines. So I've got a degree of sympathy for the tour operators in that relation because they've paid all their suppliers, they haven't had their money back, and now they've got to refund the consumer. But that is what the package travel regulations say. And until the EC says something different, that is what is required by law. And there's no derogation from that.
I think that the difficulty is, though, as you were saying with liquidity, is that, strictly speaking, legally, there's no derogation from their clear obligations. But if they simply do not have the money, they do not have the liquid capital, what can they do? And it is a case of, I would imagine, deferring payments and surviving for as long as possible, notwithstanding, they appreciate probably, what you would imagine their clear obligations, but I think it's more of a practical issue. We have then another, I think the next in time was a question that came from Rebecca on the Q&A box. So I should add, Sarah, I think you'll agree with me here. We've been going for over an hour. We'll answer all the questions that are asked, but if you do want to go, of course, please do. But only stay.
We can't keep people here.
We can't, no, yeah, unfortunately. But you know, if you do want to stay and listen to these answers. Andrew Spencer's also asked one in capitals, so he really wants that answered. But Rebecca has asked, if you rented a car for a trip and then were unable to use it due to COVID, could you claim a refund for the time you could not use it?
It depends whether it's a complete frustration. So if it's a total frustration of the contract, then yes, you get a refund. If you've used it partly, let's say you hired a car and let's say you go on holiday, and when you get to Spain, you've got to quarantine for 2 weeks. And you use the hire car to drive from the airport to the villa, and then you sit in the villa for 2 weeks, and then you use the hire car to drive back. You're not entitled to a refund because you've had some benefit from it. So it's not a total frustration. It's not complete nullity, as it were. So it depends on whether or not you've been able to use it at all. If you've got, for example, a package holiday, and then you or you booked your own holiday, and you then booked a hire car as a freestanding thing, you booked that yourself, and then you don't use it at all because you can't go on holiday, then you would, under English law, be entitled to a refund, but bear in mind that you might be looking at the contract being governed by the law of the country where the hire company is. If you're with Hertz, good luck with getting any money back at all either way, but it depends. Bear in mind that some of these supply contracts are going to be governed by foreign law, so we can't really answer that in relation to some of them. Yeah, Andrew wants to know, to what extent will tourism need to evolve to provide social distancing? Well, I think this is what Richard was talking about earlier with the roadmap, where the European Commission sees tourism evolving to provide social distancing. So it sees airports becoming very much quieter. It sees people social distancing on beaches, for example, and in restaurants and so on and so forth. Anyone who has been to Wittering Beach recently will know that that is optimistic at best. And I, like Richard, find it quite difficult to conceptualise some of our busier airports not being busy and enforcing social distancing. But that is what the Commission foresees, and they've laid out quite detailed guidance for airports, for aircraft, for airlines, for hotels, for restaurants and so on, that they envisage being followed. Although I was talking to a restaurateur the other day who was saying, well, look, I've got a garden, I will be able to open it when we open up, but there will have to be social distancing to such an extent that I'll only be able to get 30% of people that I would normally get in the garden. And he was saying it's just not worth opening up because the costs and the overheads of opening up are the same, but you're getting 70% less income. So I think the answer is yes, there will be a degree of social distancing, but how long that will go on for and whether or not that will work for some businesses, I think is debatable. I mean, I have no idea how it's supposed to work on aircraft because it's just not sustainable, it seems to me.
There was then a question on the, I think this was the next in time, on the chat box from Tony Boswell, who asked, what are your thoughts on the potential class action taken by travellers to resorts such as, I can't pronounce that name, Ischgl in Austria, where there are allegations of a cover-up by local authorities? If we as a tour operator receive claims or complaints of this nature, how should we proceed? That's quite a big question.
That one is an interesting one. It's a really big class action being brought, as I recall, mostly by Germans. So it's an Austrian resort. It stayed open even though the local authorities are alleged to know that there was a bar that was very popular with holidaymakers, and there was the barman effectively had COVID-19. They knew of that, they allowed it to stay open, and it's been at the centre of an outbreak because everyone went home then to their home countries and spread it all over Europe. So there's a class action being brought with, I think, some thousands of tourists. There are some English tourists involved in that. The problem with that, I think, as a class action, that particular instance, is jurisdictional, because I don't see how you can sue a foreign resort in the English courts. So I think there's a jurisdictional problem with that because they have to be sued in their home courts. So I think an English class action, subject to any clever ideas around jurisdiction, for which I would have to be richly paid, I don't foresee any jurisdictional prospects on that. In relation to your position as a tour operator, where you've got a resort that's subject to that kind of complaint, I think if you as the tour operator didn't know or have any reason to know, or could not reasonably have known that there was a problem at the resorts, then you're fine. But where, for example, the Lanzarote problem, if you send guests to a resort where there is known to be an outbreak, I think you're going to be in trouble. But it's a question of degree. It depends when everything happens. It's a question of exactly at what point you sent the holidaymakers out there. But I do think if you send, at the moment, in the current climate, if you send holidaymakers somewhere that you know there's an outbreak, you can be in difficulties.
I wonder with those claims, generally in terms of COVID infection, whether there will be a degree of lenience given by the courts for, you know, what I'll call like a panic factor. So when there was a window of time, I think everyone will agree that when nobody was really quite sure what was happening, everybody was panicking, countries were going into lockdown, other countries were about to go into lockdown. I think trying to establish any kind of standard for how a reasonable operator should have acted then, or whatever the equivalent local standard is, legal standard, I think that will be nigh impossible. Any kind of industry standard will be, in all but the most egregious of cases, it will be almost impossible. But that's where I think the cruise operator claims that have, you know, been lodged in, I think principally America and Australia, they're interesting because they do seem to fall maybe into that egregious category. Maybe.
That's certainly how the claims are being put in those jurisdictions.
Yeah.
Quite a lot of sympathy for the cruise operators in this.
Yeah, no, as do I. But no, you know, I just, as I said before, I just think it's very easy to look back in time and say this is how you should have acted, given that we now know what a global disaster in many ways and global health emergency COVID has proven to be. How could you not possibly have acted more cautiously at the time? But, you know, as with all things, I think hindsight is a cruel and distorting lens for analysis. So we then, I think the next question...
but I think that's where Foward's question comes in. I think if you follow the FCO advice, you can't go wrong.
But what if there wasn't, you know, for example, with businesses abroad, what if there wasn't any clear FCO equivalent guidance? Or, for example, cruise ships that may have been in international waters, or what if there isn't, you know, it's easy for us with the FCO to say, oh, it's very clear, we know exactly what we should be doing, but what if there isn't? And will it be with respect to an industry standard, a national standard? Will it be treated on a bespoke business by business?
It'll be areas. It'll be aviation, cruise industry, airlines, tour operators in particular areas. But that's where the litigation comes. If we knew all the answers, there wouldn't be litigation, would there? Yeah,
I mean, it will be really interesting, correct me if I'm wrong, but I think it will be really interesting 6 or 12-month period where, even just from an academic legal point of view, it will be fascinating to see how malleable private international law proves to be, particularly with jurisdictional questions. So you referred to maybe there'll be some clever ways around it. Maybe there will be.
Yeah.
I don't think, maybe, you know, arguably there isn't currently the legal framework to properly ventilate these complaints, but perhaps, you know, a framework could be introduced, either judicially or by statute, subject obviously to potential Frankovich challenges.
Well, actually, this is quite interesting because it brings on to Anne Dolan's question about challenging. It says, I've been thinking about looking to customers to assign their right to a refund under the denied boarding regulation, but some airlines, TNCs, prohibit passengers from assigning their rights to compensation to third parties. Could this prohibition be challenged? I did a case called Menditor and Ryanair about 1 billion years ago. That was to do with denied boarding in some form or another. And the short answer was no. If they have a prohibition, then they can't assign their rights. But there are other problems about assigning rights as well, to do with champathy and other quite exotic things. So I think there's a way around it, in that you just bring a class action. But assigning of rights is something that the English courts really, really do not like, particularly those consumer rights. So I think that would be quite trying, but it might be worth a try because things have moved on. But I think you're more likely to see consumer bodies doing that than you are to see particular firms and solicitors assigning rights in that way. It's quite difficult. We answered all the questions, Richard.
No, there's one more question from Sandy Algela in the chat box. The question is, do you think there should be changes to the package travel directive at EC level following this pandemic? In normal situations, the cancellation and refund position is reasonable, but it may result in many tour operators, especially small independents, folding. So that's kind of touching what we were saying before, that there could be, reflecting, this is the word that everyone uses, I hate it, if I hear it again, I'm going to explode, but these are unprecedented times, and the applicable law, or plausibly applicable law, may change to reflect that. But what do you think, Sarah?
Yeah, and I think the short answer is yes. I think there will be, and not only at EC level, I think there will be at UN level. So I think globally, we're all going to be looking at where risk lies. If you recall the Icelandic volcano eruption, which was...
How do you say that name?
If you don't know, then I'm certainly not going to tell you, Richard. So when that erupted, if you recall, Ryanair attempted not to provide care for people who were stranded in various parts of Europe, because they said, well, look, we provide care even in extraordinary circumstances, but these are super extraordinary circumstances. These are so extraordinary that we don't have to provide care. And the European Court of Justice had none of it and said, look, it's an extraordinary circumstance. There's no such thing as something that's so super extraordinary that it stops being extraordinary. And so you have to provide care under all those circumstances. That at that time was an unprecedented event. And at that time, there was some suggestion that the law should be changed to reflect the fact that airlines were liable to accommodate people indefinitely. So they could be accommodating people for months rather than just a few hours or days, which had been what was intended by the legislation. So at that time, there were murmurings about should it be changed. That came to nothing because by their very nature, these unprecedented events tend to recede in the mind, and then people kind of go, well, we'll never have that again. That's never, clearly nothing like that could ever happen again. Well, now we've got something like that plus. And I think actually that there is such concern, and there's now concern in nation states that have greater control over the EC. So people like the German government are having to bail out their tour operators and their airlines, and they're not going to want to do that again. So I think there is a groundswell of opinion, and actually the majority of the council member states do want to change the refunds rules. But the reason they haven't been changed is that they can't get it through the parliament because there's quite a large green lobby in the parliament, and they're not very keen on airlines. So they're saying, well, the price of changing these rules about refunds might be that we change the rules about emissions, or we bring forward reduction in emissions. So in order to change it at European level, the airlines are going to have to give something as well on environmental factors and pollution and stuff like that, and then they will get the changes through Parliament. But all of this is going to take a really long time, as everything does at international level. As I say, the UN convention is ready to go, or practically ready to go, and that altered the balance of risk and took it away from the industry and placed it more on national governments, which I think is actually quite an interesting concept. But again, as I say, that's something that in my ever popular webinar next week, I will be talking about with a member of the EC and with the UNWTO, because At the moment, they quite frankly say, look, we don't have the answer to this, but we do know that the answer isn't that the industry should bear all of the risk, because it just can't, it's a risk that's too great to bear.
There are no other questions, so that would seem to be a good time